People work their entire lives for what? To build up assets they can eventually pass on to their kids or loved ones, right? But without the right paperwork in place, everything you work for and many of those assets, like the house you own, the stocks, 401ks, or other investments, can be at risk. They are at risk from the insane cost of medical care, especially as you get older. They are at risk from creditors. They are at risk from others who may not necessarily have your best interests in mind. And in Michigan, your assets are at risk in the probate process, which happens every day. And when the estate goes to probate, the process can take up to 4 years and cost upwards of $40,000. And that is exactly what happened to Jacob. Jacob was divorced. Jacob had one adult daughter named Carrie. Jacob remarried. Both before his second marriage and after, Jacob named Carrie as the beneficiary of his retirement account, but didn't do any other estate planning documents or consult with an estate planning attorney. Jacob died unexpectedly in his 50s. Jacob's second wife learned that she was entitled to his retirement account due to a federal law that required the spouse to sign off when a non-spouse is named as beneficiary, or the beneficiary designation does not count. After applying the Michigan law to the rest of Jacob's estate, including his house from his first marriage, his cars, and his savings, Jacob's second wife was entitled to 80% of the remaining assets and 100% of the retirement account, all because Jacob failed to plan with a knowledgeable estate planning attorney. In fact, Carrie's personal car was at risk because she left it in Jacob's name for the cheaper insurance rate. On the other hand, I had another client named Linda. She came to me for help to go through the probate process when her husband died. He owned a plumbing supply business and had bank accounts in his sole name. After a year, everything was sold or transferred to Linda, but it cost money and time that could have been avoided. Linda did not want her kids to go through this when she passed, so she asked me to do an estate plan for her. Approximately 3 years later, her son called me to let me know she had died 3 weeks prior. I asked if he needed any help to take care of her estate. He said no. He just wanted to call and thank me because it was already done. All of her assets were already taken care of within 3 weeks because we set up an estate plan that avoided probate and simplified the process of winding up Linda's affairs. I'm John Tatone, and since 1996, I've been helping Michigan residents and blended families protect their assets and avoid probate. Nobody wants to think about getting old, becoming incapacitated, or death, but it's something we all have to face. Estate planning protects your assets and your intentions. It's what takes care of those you love when you are no longer able to do so. An estate plan serves as a set of instructions to carry out your wishes. When there is not an estate plan in place, your estate will be forced into probate, which can lead to assets being tied up for years and costing tens of thousands of dollars. Ultimately, having an estate plan is what protects your family. Be the hero to your family. Schedule a time to meet with our firm today and take the first step in protecting your family's future. I'm John Tatone, and I look forward to working with you.